Right, so we have here LAWS12066 land law, and this is the lecture recording for topic 7 on leases. Now, folks, I'm going to divide this into two parts. So this first recording will take us up to the end of covenants, and then the second lecture will deal with the balance of topic 7. This is a huge topic, folks, and we need to have a good roadmap in terms of what we're doing, and we need to break up the material and just realise the terrain we're covering. So 2 lectures for this topic, and this topic will cover 2 weeks of the unit, which has already been foreshadowed, and that will be our coverage will be reflected in terms of how I've divided up the lectures. So I'm just going to screen share the slides. So we are here in a topic on leases, and where are we going? We're looking to identify the essential characteristics of a lease. We need to work out in any given situation how can you decide whether or not you've got a lease or a leasehold interest in land. We need to then think about the rights and duties of both parties to the lease, that is the landlord and the tenant, or the lessor and the lessee under the lease. And we need to be able to work out what are the way in which those rights work. We need to think about consequences of breach and assignment, and then other matters that we'll look at in the second lecture. Some key words there, as you can see, in relation to this. The thing about the topic on leases is that we use these phrases lessor, lessee, landlord, tenant to some degree interchangeably. And in commercial situations, we tend, and situations governed by what I'll refer to as the general law of leases, we refer to lessor and lessee under a lease, okay? In other situations, particularly in a residential situation, residential occupation situation, under legislation, as it is in Queensland and other jurisdictions, other states and territories, we refer to landlord and tenant. But we can also interchangeably talk about the lessor as the landlord, and we can talk about the lessee as the tenant. Okay, that is also possible. You might recall that we started this discussion around the nature of the leasehold interest back in the Term 1 unit in the property foundations of property law, when we looked at estates in land, and one of those estates today is considered to be a type, the leasehold interest. So this is a continuation of that, but in a far more detailed fashion. We'll come to these other terms when we get to the second lecture. Right. So I just want to, before we get to the key legislation, I'll stop that for a moment. And I just want to say that in this area on leases, what we are essentially looking at mostly is the general law of leases, and that means the law, the property law and the land law that is governing today what is essentially a commercial lease situation, because other types of leasehold interests are actually governed by specific legislation. And we see that toward the end of this unit. There's specific legislation governing residential tenancies. there is specific legislation governing retail shop leases, which we touch upon just toward the end of this unit, but we don't really go into it in any detail because it's quite involved and it's a bit specialised and it really requires separate treatment. We just mention it, we bring it to your attention. And in Queensland, there have been recent reforms in that area of retail shop leases in 2016. So we'll mention those when we get to that. And so we've got these different legislative regimes dealing with particular types of leasehold interests. But our main focus is on the general law lease and how both framework of legislation, both under the Property Law Act and the Land Title Act, is relevant in terms of the nature of that lease, the interest that is on foot between the lessee and the lessor, and the rights and the obligations between the parties to the lease, what can and can't be done, and then ultimately, in due course, we'll see issues around transfer of interests, both by the lessor as landlord or as owner, and by lessee as the holder of the leasehold interest. And then ultimately, how can a lease be brought to an end? And also, very importantly, about remedies. What can be done by either of the parties, the lessor or the lessee, if problems arise, if terms or covenants haven't been fulfilled or they've been breached, and what can be done in that situation, and what does the law have to say about that? As ever, remedial outcome is very important for the parties and in advising clients. All right? So that's the other thing I just want to, at the outset, bring to your attention is this is an area also which is, as we've seen, dealt with in the Property Law Review 2018, and that's because the Part 8 of the PLA deals with leases and tenancies. Now, this is a substantial discussion in the PLA review. It actually is a discussion you can see there. It starts on page 579 and it goes through to 776. Well, that's nearly 200 pages, and I'm certainly not asking you to read 200 pages of this review. You be aware of it. You might just have a bit of a look at it from time to time as you're thinking about this area of leases. And when the different sections come up that we discuss, you have a look at. Maybe there's the discussion that and any suggestion proposals for reform that are being made in the review in regard to that. Stop screen sharing that for a moment. Now, the other source I just want to quickly identify for you and bring to your attention, that is the legislation, PLA, very important. And we'll also see shortly that the Land Title Act also is relevant. But if you see here in terms of the PLA, Part 8, as I indicated before, you can see just a quick run through there. So the first division deals with rights, powers and obligations. Division 2, surrenders, assignments and waiver. Division 3, relief from forfeiture. Come to that when we look at remedies. Division 4, termination of tenancies. Division 5, recovery, summary recovery of possession. So this is something that is very often a remedy or a relief that a landlord is looking for. They want to take back the possession. So that's an area that's covered by the legislation. And then also a specific area, we don't really go into this too much, but just to be aware of it with regard to agricultural holdings. And you'll notice that there's a bit of a discussion in your casebook regarding agricultural leases in Chapter 7. Right. So I'll just stop screen sharing that for a moment. And I just want to now show you the Land Title Act. You can see there that under Part 6, dealings directly affecting lots, and Division 2, dealing with leases. So this is the provisions in the Torrens Act dealing with leases in terms of Torrens land and what is possible with regard to registration and whether an existing lease interest can qualify as maybe some way affecting a registered interest, for example, that a registered proprietor has, and so on. So those provisions there are also important for you to be aware of in terms of this area of the law of leases. So we'll just go back to slides. And so there we are. We see that these are the areas of the legislative framework with regard to the law of leases that we need to be aware of. And you can see there I've spotted for you the relevant sections in the PLA and the LTA that I've also just highlighted. And then we'll come back later in the second lecture to these other acts that are legislation that's been passed to deal with specific types of lease interests. So we'll deal with those in the second lecture. So the first idea that we need to tackle is, what are the characteristics of a lease? How do we know whether we've got a lease? Okay, what is a lease? What are the fundamental ideas that a lease entails? Right. So we'll just go back to sharing the slides. Now, just before we get to the characteristics, I just want to again point out that this is a substantial topic, and there's this, the chapter 8. It's chapter 8 in the casebook on leases. It's a substantial chapter, right? It's only 150 pages. Okay, but in breaking it up into 2 weeks like this, I've chunked it up into 2 portions, approximately half and half. So the first part of the chapter of about 80 pages goes from 695 through to 775, right? That's from the beginning up until this idea of assignment or enforceability of covenants after assignment. And then the second part of this coverage, which we'll deal with in the second lecture and in the second class, goes from page 775 through to the end of the chapter on page 851, again, about 75 pages. So the point there is trying to make the progression through the material manageable for you. I know that that's a substantial chunk of reading, and I appreciate that. Again, you're focusing on the discussion that relates to the Queensland arrangements. There is discussion there with regard to general law, which is generally applicable to Queensland and to other jurisdictions, and then the discussion with regard to situation in Queensland under the Queensland provisions. Okay, so just note that. So coming across then to this idea of the characteristics, the central characteristics in terms of thinking about whether we have a lease or not, whether, and we can't, just another point is, come back to this idea of between substance and form. So that just because a document, for example, is headed up a lease, doesn't mean that you actually, that reflects a lease or the creation of a lease. It must be a lease according to the requirements of law, okay? And the law looks to these essential characteristics. And these characteristics relate to exclusive possession and certainty of duration. Does the lessee have exclusive possession for the period of the lease? And is there a certainty with respect to that period of the lease? What's interesting about the nominating and identifying these characteristics is the fact that you don't see mentioned there the idea of rent. And you might say to yourself, really? Surely the payment of rent is fundamental reason and rationale for why property is leased or rented out to generate a source of income to the landlord. Of course, it's true that that is a prime motivation for owners of land to lease property and to or rent property out. But it's not that actually is a fundamental characteristic of what a lease is according to law. These ideas of exclusive possession and certainty of duration, they are the fundamental ideas. So we need to be able to establish that the lessee has exclusive possession for the duration of the lease, and that we can determine that there is certainty around the duration. And you see I've just referred to some cases there which you can have a look at. The notes also refer to the more recent Swan and Eka decision of 2016. That involved an Airbnb scenario. So you might like to think about how does exclusive possession work in the context of an Airbnb type scenario, and see what the Victorian Supreme Court resolved in the Swan and Eka case. And you'll find that discussed at, as I mentioned, in the notes at 8.25 capital C. From there, we need to be mindful of the types of leases that are possible, and we have tenancies of fixed term. We also have tenancies that are referred to as arising at will. Now, a tenancy of fixed term is fairly self-evident. There is a specified term that is in the lease. Coming back to that characteristic of certainty of term doesn't mean that the term has to necessarily be specified, but that there is a certainty with regard to duration that is reflected through the lease arrangement and the lease relationship between the landlord and lessee. It's not totally undeterminable. Okay, that's the point. A tenancy at will, as you see from the notes, this really arises where a person enters into possession under a lawful right and remains in possession when that right expires with the consent of the landlord. So it's sort of at will of the landlord making the decision about how long this should continue. And I also just referred to this idea of what's identified today as green leases in the Queensland situation, and you can have a look at that in how that's discussed in real property law in Queensland. So this idea of green leases is not a specific category of leases that the laws, the general law identifies, but it has arisen as a response to environmental concerns and environmental issues, and a definition has been proffered of a green lease as follows: a lease between the landlord and tenant of a green building or a conventional building that is proposed to be refurbished as a green building, which incorporates ecologically sustainable development principles that ensure the ongoing use and operation of that building, minimising environmental impacts. And there's also in real property law in Queensland text discussion of the acknowledgement of the Commonwealth Government's energy efficiency in government operations policy statement from 2006 and legislation that's responded to that. This is an indicator that today we need to understand that there are other drivers in relation to the legal framework that we have. And it's not just about the traditional legal frameworks found sourcing from the general law obligations and rights that have been determined over time in conjunction with how legislation has intervened to establish certain protections or make specification in regard to certain aspects. But other developments and initiatives are relevant both domestically and internationally. And here is one where we're finding a response to environmental issues and its impact with regard, in this context, to landlord type relationship. This also tosses up another point that you should be aware of, and I've put these for you on the Moodle website, and that is the Sustainable Development Goals. And so I just want to, at this point, share those Sustainable Development Goals with you, which are on the Moodle website under the welcome page. You can see there that the two that I've chosen, which I think are most relevant for our studies in land law, and just in light of this discussion of green leases, this comes up in this context. So you can see there, Sustainable Development Goal 11, to make cities inclusive, safe, resilient and sustainable. Now, focus on cities, and I know that many of you are in regional Australia, not just in cities, but this is has broader implications in terms of its impact and consequence. And so that's a relevant goal. And then, stop sharing that for a moment. And I'll just screen share the other Sustainable Development Goal, and that is Goal 9 with regard to industries, innovation and infrastructure. Now, again, it's not, completely just about land and the relationships there in terms of how the law is governing use of land and whatever as we've been discussing, but it is clearly relevant in terms of this notion of innovation and also with regard to infrastructure. Land is part of what is needed for the building of infrastructure. And also this comes back to our point earlier in the course with regard to the use of land. And to some degree that also ties in a bit with, alienation of property that we've looked at in the last lecture, that property has a usefulness, has a utility, and so on. So just be mindful of these Sustainable Development Goals as larger international drivers in terms of how we need, just going to stop screen sharing that, how we need to think about how we should govern these relationships that historically property law and land law has identified, but there are now these other factors that can come to bear in thinking about those relationships. So I'll just go back to the slides. So there we have those types of leases. So in terms of how we go about the creation of a lease, again, we're focusing on the situation, of course, in Queensland. Here we're really looking at how can a lease come into being, and also, in a sense, some of the formal requirements. We've seen this idea of formal requirements before. Again, if we go back to the Term 1 unit, we saw that formal requirements with regard to dealing with interests in land, requirements for writing and so on. So in the Queensland context, we've got that a lease creates an interest in land. The leasehold interest requires registration over the landlord's title so as to become a legal interest capable of enforcement. This is in relation, the idea of registration, of course, is in terms of the Land Title Act. In Queensland, leases of 3 years or longer are required to be registered to take effect as a legal lease. So there we have the registration issue again and the obligation. And if a lease is of 3 or more years and remains unregistered in Queensland, it may be that the lease will be enforceable in equity. So here, again, we have this idea of, well, within a system where private freehold is Torrens title, what is the effect of registration, and how do we recognise the interest that has remained unregistered and hasn't formed part of the Torrens register? That takes us back to what we looked at in topic 4 with regard to unregistered interests in Torrens land. In terms of the idea of the impact of the Torrens system and the registration of leases, we've got provision within the Land Title Act, Section 64, that is relevant. And we have also got this decision that we saw again in the Term 1 unit, mercantile credits and shell, just in relation to the nature of that interest that the lessee has, and that it can get the protection of registration. And then once it's registered, of course, it becomes an encumbrance on title in terms of the registered proprietor's interest. And were you to search the register, you would see it. If it is registered, there it is, and it would be referred to by its number as an encumbrance on title. We also need to identify the fact that the leases can amount to a statutory exception to indefeasibility, and this is covered in the Land Title Act in relation to short leases being an exception under Section 1851B, and there's also other provisions there that you can see identified in regard to how a leasehold interest can qualify as a statutory exception to indefeasibility. So this then takes us back to this idea that these types of interests are part of that regime of statutory exceptions. And we go back and have a look, for example, at Section 1851. There's a number of exceptions there to the indefeasibility that a registered proprietor obtains on registration, that the legislation recognises. So again, that is something that, as we discussed earlier in the unit, what we need to appreciate in thinking about the quality that indefeasibility gives to a registered proprietor. All right, so just continue where we left off. The next point that we come to is this idea of an agreement for a lease. And this is discussed in your casebook at paragraph 8.33 and tosses up the early English decision of Welsh and Lonsdale, which we also looked at in the Term 1 course on property law. The point that this brings out is that you can have dealings between the parties prior to the creation of an actual lease, which is a proprietary relationship and actually confers a proprietary interest on the lessee in the nature of the leasehold interest, which property law will recognise, and to which exclusive possession will be accorded. And that's very important. And it is also an interest, ultimately, as we will see in the next lecture, that can actually be transferred or assigned to a third party. That's the interest that the lessee has, just as the landlord can also do that by selling property. Okay, that's property law and its governance of that relationship. But the parties can be engaging with each other, dealing with each other, and in effect, actually enter into an agreement, which is ultimately a contract. That means that they haven't yet entered into a property law governed lease, and that's not the nature of the relationship, but there is an agreement to lease, it is in the nature of contract. The general law of contract will be relevant so long as it meets the requirements with regard to an agreement concerning an interest in land, as we've seen previously. And in that case, then law will be relevant in terms of enforcing the agreement. But again, if all of the formality requirements with regard to a contract that's dealing with an interest in land haven't been met, so that then it can't be enforced at law, equity will be able to be utilised to enforce the obligations, and, for example, an order of specific performance may be sought. But this is something that is in, it is about an agreement to lease as opposed to the actual entering into a lease. And often this is a point of differentiation that you need to appreciate, particularly in commercial transactions. Large commercial parties can often be dealing with each other. They can get to a stage where effectively they've got an agreement, but they haven't yet got to the point of actually formalising that into a property law lease. So that's just something that we need to be mindful of and to be on guard in terms of the areas that are relevant. The other thing is, folks, as we just proceed forward in this, remember that as a property lawyer, if you're dealing in this area of advising clients with regard to leases, and again, we're talking mostly here about commercial leases, this legal framework today is the framework that relates to commercial leases. You'll be acting for the lessee or you'll be acting for the lessor. You'll need to ensure that you actually have a lease, as we've pointed out. In this situation that if the parties want to have a formalised lease, that they don't just have an agreement to lease that's then governed by the law that deals with agreements or contracts as opposed to the relevant provisions dealing with leasehold interests, and that the rights in terms of the party that you're advising have been appropriately protected and reduced to writing in the actual lease itself. We'll see that more specifically in a moment when we come to the covenants, both in terms of the matters that can be expressly put into the lease and the matters that are otherwise dealt with in law or implied. The parties often want to put things specifically in a lease, and then we get to the point about the negotiation between the landlord and the tenant, or between the lessor and the lessee. Now, unlike in other situations, residential tenancy, for example, in the commercial situation, the lessee often has far more bargaining power. A lessee will come in and want to do something with the commercial premises, run a business that might be quite different to the previous business that was run from those premises. Changes may need to be made to the premises, and the landlord, the owner of the premises, will need to accede to those to allow the business to come in. So much more negotiation around what can be done, what can't be done, the rights and protections that the law gives, but also that the parties specifically want to deal with, including issues around the duration of the lease, the rent that's being paid, and any other particular matters that might arise from the nature of the premises, the nature of the business that's being run from the premises, and so on. So we move on from that to look at some further aspects of leases. And again, this is discussion in your casebook, page 718 and following. So we've got then the idea of implied leases at law. We've got yearly periodic tenancies, and the relevant case there is Doctrell and Kavanagh. We've got other types of implied leases, and the Leeds-Leaholm case is important there in that regard, in regard to how do we understand the nature of the duration of the lease in terms of how rent might be paid. So, for example, if rent is paid on a weekly basis, it will be implied that a periodic tenancy exists on a week-to-week basis, and that notice to terminate will be 1 week's notice or the equivalent of the rental period. So again, the law has identified the existence of a lease, even though we haven't got an actual specified term, but there is that in the nature of the dealings and arrangement between the parties, sufficient certainty of duration so that it ticks that box and we actually have a lease in existence and on foot. There's also the idea of a tenancy by estoppel, and this also tosses up the idea of the role of equitable estoppel. And you recall from various studies actually that you've, various units that you've undertaken, both covered in the earlier property law course, but also in your contract law studies and in your equity studies, about the role of equitable estoppel. And basically the point here is that you can't, estoppel won't allow a party to resile from undertakings that have been made where it would be unconscionable to do so. And the Walton Stores and Marr case is a classic scenario of that, and you've covered that both previously with me and in other units of study. So be aware of that. Right, so once we deal with those different variety of lease situations and types of leases that the law has identified and that equity might enforce, we now come to the next critical area within this topic on the law of leases, and that is covenants. Now, we refer to these as covenants rather than terms because they're in this property law relationship, and they, as you will appreciate, a covenant is a term of special significance and importance, and it's not. This is not a contract. Okay, so we've moved beyond this idea of an agreement to lease. We're now looking at an actual lease. It's a property law relationship, and the rights and obligations between the parties are found within the covenants. Now, we have a variety of sources of these covenants, and you can see, for example, there the areas touched upon in your casebook just at 8.57. So just we have covenants implied by law, covenants implied by legislation, primarily the Property Law Act in Queensland, covenants by necessary implication, so that situations, circumstances between the parties necessarily and the type of what this lease relates to leads to certain things being implied, certain covenants being implied, or covenants the subject of express agreement between the parties. Now, that's listed as last, which is interesting because this is something that the parties are very often want to commit to and agree upon. Now, we certainly, in a matter from a practice point of view, we can have standard terms that can be put into a lease, but and we can have a lease form for the purposes of, for example, registration under the Land Title Act and on the Torrens Register. But all of the covenants and so on, there's not a standard form. For example, standard forms, standard contracts of sale and purchase. We have standard forms for residential tenancies, for instance. But in commercial tenancies, commercial leases, it's different because the nature of the relationship, the nature of what is being leased and the nature of what is being sought by the lessee determines what are the rights and obligations between the parties. But there are certain things that have been recognised by law and that arises through the general law and also through legislation. So just looking at these general areas, and you can see that this discussion goes from pages 731 to 775. So it's about 40 pages. Okay, so 40 pages on the covenants is a substantial chunk of the discussion within the chapter. And what you're trying to get a sense of is the areas that are covered, right? What are the type of things that are dealt with in terms of the relationship between landlord and tenant, landlord, lessor, and tenant lessee. And how are these dealt with either by general law or by legislation, or might be something that's subject to express agreement? You need to, as you see the different areas covered, you need to think about, well, what's the purpose of the lease, right? The lease is being offered as a way of generating income for the landlord, even though we've said that rent's not a characteristic of a lease from a land law or property law perspective, but that's a practical, rationale for why it's happening. What's happening is that we've got premises that are being leased, and that's for a purpose. And then we need to think about, well, how can this happen in a way that allows the lessee to run and operate their business? What might the lessee need to be doing to make the premises suitable to their business purpose? What should the owner or the landlord, what sort of obligations should they have with regard to these premises, right? And so on. So we see here, for example, we've got quiet enjoyment. The lessee has a right to quiet enjoyment, and this is part of exclusive possession. It won't be interfered with by the landlord coming and banging on the door every other day and so on. The landlord has a duty not to derogate from the terms of the grant, and you can see that's discussed for you it's starting at 8.64. So this idea of the not derogating from the grant requires the landlord or the lessor not to allow any anything to somehow operate in a way that's inconsistent with the leasing of the premises. Okay, and there's a reciprocal duty on the tenant. The tenant would use the premises in a tenant-like manner. Okay, so that the tenant or the lessee will do things not in the nature of being the owner of the premises, but being in the nature of being a tenant or a lessee who has the rights of exclusive possession and quiet enjoyment, but doesn't operate in a way to be suggesting to all the world that they're the owner of the premises. So that's this idea of not derogating from the terms of the grant. There can also be liability in regard to the acts of others. So when persons come onto the premises, you can imagine in a business situation, of course, there are patrons or clients coming in to the premises to access the business in whatever that business might be. You can think of a whole range of possible situations or scenarios in terms of the business. What happens if the patron or the client gets injured? Or what happens if they do something that actually damages the premises? Who carries liability in that situation? So you've given you a couple of cases there that you can have a bit of a look at in regard to that. And the Aussie Traveller decision and Mark Lee, which is a Queensland case, 1998, is important in this respect. And you can see that discussed at 8.69c. Have a look at the nature of the lessor's liability, and also that case discusses extent of the disturbance necessary and so on. And then there's some quite useful discussion in your casebook about the Aussie Traveller case after that. There's then this obligation to repair, and there's differences here between furnished premises and unfurnished premises. And again, we're thinking about a commercial situation, but the nature of furbishment of premises can be interpreted in different ways in relation to premises that are being used for business or commercial purpose. We've also got this idea that there's a landlord duty to take reasonable care for the safety of the occupants of the premises. Don't forget the landlord is the owner of the premises, and insofar as the owner is leasing the premises to a lessee, mostly for running a business, as owner, the landlord has some overarching obligations here. And you can see that idea of the safety of the occupants. Jones and Bartlett which is a 2000 decision of the High Court, important in that regard. And you can see that partly that decision looked at that duty to the tenant, but also considered the nature of dangerous defects and duty of care obligations, both in terms of the tenants, the occupiers, and other people that came onto the premises. So have a look at the Jones and Bartlett decision in your casebook with regard to that. We've also got this idea that the tenant has this, as I've already mentioned, a duty that they will use the premises in a tenant-like manner, so be aware of that. The tenant has an obligation to yield up possession when that's required, and the law demands that, or subject to the requirements of the lease. Now, we have also specific covenants that are specified under the PLA, and I've already mentioned the review of the PLA, and you can have a bit of a look at that. Just, some of these sections, 105, 107, for example, and just get on that note. But so have a little bit of a look, but certainly not asking you or requiring you to look at 200 pages of the review report. But just be mindful that it's there in terms of making some suggestions for improvement or change. So under the PLA, we have a covenant by the tenant to pay rent, rates and taxes under section 105. But be mindful that there are exceptions within the Queensland framework and have a look at those. Go back to the legislation. The covenant by the tenant to repair under section 105(1)(b), which is applicable to fixed term leases exceeding 3 years. The landlord's right of entry for inspection. So, the landlord has a right to come in and inspect the premises from time to time to see how they're being used. Is it being done according to the lease, according to law? And very typically, of course, in a commercial situation, the landlord may do this themselves. They may have an agent that can come in and look and check things over and just make sure everything's okay, because they want to make sure that the premises are being used appropriately and in accordance with how they've been leased. The landlord has a right of re-entry for non-payment of rent under section 107. So there is specification with regard to the entitlement where there's arrears of rent, and the landlord's right of entry for breach of covenants other than the covenant to pay rent under section 107 paragraph D. So rent's identified specifically, and then breaches with regard to other breaches and what are the rights of the landlord in that situation. So just be mindful of that. And when you're having a look at the casebook in this regard, again, just of course it's referring to all the jurisdictions as the casebooks tend to. So again, you're focusing that, drawing from that discussion what's relevant in the Queensland context. Right, so we now move to this idea of express covenants. And you will see that the express covenants, the discussion in your casebook starts at 757, and these express covenants, which the parties themselves can incorporate within the lease document, the written document, covenant to repair, covenant against assignment or subletting. So that's about the transfer of the interest, or subletting is a situation where you're taking part of the premises and you're allowing another occupant to come in and maybe run a separate business, and so the lessee is deriving income from that subletting situation, which may be used to contribute towards the rent on the primary lease. So this idea that the landlord is requiring something in, needing to approve this before it can happen. A covenant as to user, that is how you can use the premises, and that's part of the discussions, of course, that I had prior to the creation of the lease between the parties in terms of, well, what is the lessee going to do with these premises, and the covenant to pay rent, again, in terms of the express covenants. Just referred to some cases there that you can have a look at in your case book. One interesting one is this idea of inherent defects, which is discussed at page 763. And this is really about the lessee's obligation of repair, so that where there is this covenant to repair, either expressly undertaken or, as we've seen, this under the implied covenants. But what if there is some inherent problems with the premises, with the land that are being leased? Is that something that the lessee also has to take responsibility for? And so this really is an exception, but determining what an inherent defect is can be a bit challenging sometimes. And this takes us back to the factual situation, okay? Determining, is it an inherent defect? What does that mean? Does it mean something that exists when the lease came into being, or something that's fundamentally wrong with the building, with the premises, or whatever? Don't forget, this goes back to the obligations of the landlord as owner of the premises, as opposed to the lessee really essentially getting exclusive possession and the right of quiet enjoyment to run their business and to occupy the premises for the duration of the lease. We also, something that can be dealt with by way of express covenant is the measure of damages. Now, we'll come to this again really when we look at remedies, but that's something that can actually be specified by the parties in the lease itself, and often is. So just be mindful of that. I've already touched on this idea of the covenant against assignment or subletting, and you've got the Queensland decision there of Hamilton Island Enterprises and Boss, and you can have a bit of a look at that in terms of how that works and how that is able to be enforced. It essentially, the landlord is seeking to prevent this from taking place, or upon the basis that they are prepared to accede to, or very often not at all. Again, we've got covenants that can be reduced as covenants into the lease itself, but these other matters of covenant as to user and option to renew are also dealt with under the Property Law Act. And the option to renew is basically this idea of the option to renew the leasehold interest, okay, and how that's to take place. That's different to, we've seen previously that there's an idea being tossed about in terms of an option to purchase. So sometimes a person that has a leasehold interest may actually have an interest in purchasing the land or purchasing the premises. That happens, but that is different to this option to renew. That's about renewal of the lease, and very often in a commercial situation, the term is undertaken for a term with an option to renew for a further term. That's often something that is done. So that's dealt with in terms of this idea of options. Right, so that's where we'll stop this first lecture. Just stop the recording at that point. Stop the slide sharing. So that's where we stop the first lecture at this point. In the next lecture, we'll continue on with the idea of assignment and remedies and termination, and also the specific legislative frameworks dealing with particular types of leases, such as retail shop leases, and to some degree, and also touch on the idea, the arrangement and the framework for residential tenancy situations. So there we are. Law of Leases, Part 1. Bye for now.